In the name of God, the compassionate, the merciful. Good evening, friends, and welcome to the 17th episode of Crime and Punishment, a legal podcast, not a political one. A podcast, the official podcast, that is, of the Invictus Law Firm, PA, a criminal defense law firm in Orlando, Florida, the website for which is augustusinvictus.com. I'm here tonight with my trusty co-host, Tiger Jin, and we are simulcasting to YouTube, Periscope, DLive, and Twitch. We are going to eventually post the link to the newsletter. We've started putting it out on Mondays so that y'all will know when this is going on. But first, let's talk to Tiger Jin. Tiger, are you there? And can you hear me?
Yes, I can hear you. I was able to hear the intro.
How about that?
And to everyone, I got a new microphone. Yay.
Yeah, so we got a new microphone. We got our esteemed producer to fix the audio settings. If you cannot hear Tiger, please, it's just don't tell me, because I can't deal with the heartbreak tonight. No, just kidding. If you can't hear Tiger, please let us know, because we got to fix this. We've had a problem with that for a long time. So hopefully tonight it is fixed. Let's talk about some legal news. Tiger, you are our resident expert for the Chauvin trial. What is going on with his trial? Last I heard, we had a motion for new trial filed, but there was no hearing set. What's going on with that?
Yeah, I mean, no news on that front of the trial. Not any that I've seen or heard of. I don't know. The latest thing that you see the news outlets talking about is about the sentencing. The prosecution is asking for Chauvin to be sentenced for 30 years. And the defense is saying, no, Chauvin should get time served and he should be out on probation. He should not even go to jail.
Right, well, naturally, that's what a defense attorney is going to say. Plus, Chauvin has presumably no criminal record, right?
That is correct. They say he has no criminal record.
So that would make sense. Let's see what CNN has to say. I'm sure that's going to be neutral and unbiased. Breaking news. All right, prosecutors request 30-year sentence for Derek Chauvin while defense argues for new trial. Prosecutors for the state of Minnesota are requesting a 30-year prison sentence for Derek Chauvin, the former officer convicted of the murder of George Floyd, according to a sentencing memo filed Wednesday. That might be the most fair sentence I've ever seen on CNN.
Yeah.
Nothing but facts. How about that? 30 years is twice the upper end of the presumptive sentencing range, according to the memo filed with the District Court of Hennepin County on Wednesday. It would properly account for the profound impact of defendant's conduct on the victim's family, and the community, the state argued. That's an interesting statement, isn't it? It would account for the profound impact of the defendant's conduct on the victim. Obviously, the victim is dead. Obviously, there's profound impact. The victim's family, of course. Of course. In every case where somebody dies, the victim's family is impacted. And the community. Now that is interesting. Twice the upper end of the presumptive sentencing range. They're trying to put him in jail prison for twice what he should score, because of truly the profound impact on the community. In other words, the mob is so upset that we have to double the prison sentence that he actually earned. Allegedly, assuming it was a fair trial and he actually did murder George Floyd, we have to sentence him double because the mob is so outraged. That's translating the legalese for you. With just weeks until the former Minneapolis police officer's sentencing, Chauvin's attorney, Eric Nelson, argued in a filing Wednesday that Chauvin should instead receive probation and time served, or at least a sentence less than what the law guides. So, let's back up and talk about what it means to have a guideline or a sentencing range. So, gone are the days, mostly, and we hope, in many states. We should just say it depends. That's really the right answer in law all the time. Some states, right, let's talk about this state. There's a range of sentencing, right? You can't just, a judge doesn't just decide off the top of his head, well, I think, I don't know, what do you think? I think this is a good 45-year sentence, right? No, I think you should get probation. Like, you can't just willy-nilly flip a coin and pick somebody's sentence. Now, I have heard in South Carolina, in York County, South Carolina, there were some judges who would do just that. They'd talk to a defendant. This is when they had the old school courtrooms. You could look outside, and they'd say, look outside, count how many red cars there are. And they'd count them, and he'd say, that's how many years you're going to prison. There are horror stories like that. You can't do that anymore, right? You have to have some kind of reason, and many legislatures have decided that they're going to do guidelines so that if you score a certain number of points, this is the number of years you score. So if it's your first offense, it's a misdemeanor. The mathematics on your what we call your score sheet are not going to add up to prison. So you will get probation for a term of months or years or whatever it is. In a case like this, so your score, your points, they add up based on your prior convictions. They add up based on the severity of the charge, things like that. So there are formulas. It's complicated. It's different for every state, I imagine. So in this case, they are saying that the crime here, apparently, now it's not in plain English, but if they're saying that 30 years is double the upper end of the presumptive sentencing range, we're assuming that the actual score for Chauvin, he scores about a 15-year prison sentence on the upper end of things, which means it could be a 10 to 15-year score. It could be a 5 to 15-year score. I don't know, because I don't know, Minnesota law. But it looks like the upper end of what he scores on that sheet of paper with the math of the severity of the charge, his prior record, etc., is 15 years. Now, this is what the news article is about, is deviation. So on one side, the state is going to argue that you should deviate from those guidelines, or you should allow an upward departure. I don't know which they're arguing for because it's not in the article. But you can argue that the severity of the crime, or, as they're arguing, the profound impact on the victim who's dead, or the victim's family, or the community, or whatever it is, or some other aggravating factors, that should mean that the judge should sentence more than what the guidelines say. On the other side, obviously the defense counsel is going to say, we should depart from those guidelines and we should go way under what he scores. And we're going to take into account the fact that it was unintentional, the fact that he is a police officer who has faithfully served the law for however long he did. We're going to say that he's never had a record, which is presumably true. He's never committed a crime before, or so we imagine. He's never been convicted of one, certainly. So all those things mean that we should go below the sentencing guidelines. So that is what's being argued about, and that is what the article is about.
So I want to get your take on this, because the judge did find aggravating factors for his sentencing. I no longer have them in front of me, but one that I remember that I don't feel good about is they said he committed the crime in front of children. That's one of the aggravating factors. And I don't know if you remember or know, but that small crowd of people that was in front of Floyd, among them were 2 minors at the time. And one of them was the one that took the infamous footage. But here's the thing about that, is that crowd of people were not there when Chauvin first was arresting George Floyd and pinned him down on the ground. Rather, there was one black guy who came up and was like, hey, stop fighting the police officer, and only later did this group of people arrive. So to me, I don't think you can, I don't know, can you say that's an aggravating factor if the children show up to watch later?
Well, the answer is that it's really up to the judge. He can say whatever he wants, right? And it's up to the appellate court to say, no, we don't think so. But good luck with that. They're going to say that the trial court had discretion. They thought it was an aggravating factor. They were closer to the trial. They got to see the witnesses. They got to see the facts of the case. The appellate court didn't. So they're going to trust that unless there was some clear abuse of discretion, that the judge made the right call. I imagine. I mean, I don't know what the standard of review is in their state. I don't know. But I'd imagine the appellate court is going to say, he was closer to it. He knows the facts better than we do. And if he thought it was an aggravating factor, we're not going to second guess him. As for what I think about children being there, I don't know. How long did this go on? I still have not looked into this case. I've been agnostic about it the whole time. I've maintained a professional distance. So I don't know. How long did Chauvin have him on the ground under his knee?
Well, they say it's 9.5 minutes. Now, how long that crowd was there, I don't know either.
That's what I'm saying. All right, so if it's 9.5 minutes, kids can run up. I mean, it's in a neighborhood, right?
Yeah. It was on a very popular street. Yeah.
Well, that's
right
the thing.
Right in front of a store.
It's a popular street. He's a police officer out in public arresting a man in public. Why would there not be children around?
Yeah. Normally, whenever I would see, so in my state, it's literally like a crime to commit a crime in front of children. Like that's something else that they slap on. And normally when you see that, it's in domestic abuse situations where a guy's beating his wife and the kids are there.
Allegedly.
Yes.
Yeah, it's something that they slap on. Like you said, there are a bunch of add-on crimes, and the point of them is to throw as much jail time as possible so that someone will just take the plea. That's Prosecution 101. Throw as much time as you can, hope that it scares the guy enough into taking a plea, and then you're done with the case. You don't have to go to trial. That's the game.
And
so
now here, I think the game is just convict Chauvin of everything possible, because he also has the federal crimes coming up and tax evasion charges that just throw everything at this guy. Tax evasion? Yeah.
That's news to me. What happened there?
Let me see. The article I have in front of me mentions it again. Let me see. If I remember correctly, it was just not paying his taxes, but let me see.
Well, while you're looking that up, I got to read this paragraph here. Mr. Chauvin asks the court to look beyond its findings to his background, his lack of criminal history. These are the elements that the defense counsel is arguing and why they should depart downward and give him a lesser sentence that the guidelines would give him. So they say his background, his lack of criminal history, his amenability to probation, to the unusual facts of his case, and to his being a product of a broken system. That's an interesting argument.
Yes, it is.
So it is systemic police violence, and the police system is corrupt. And even the defense counsel is saying that should maybe not exonerate Chauvin, but at least excuse his conduct to the degree that he should be given a lesser sentence. That's an interesting argument. Mr. Chauvin's offense is best described as an error made in good faith reliance on his own experience as a police officer and the training he had received, not intentional commission of an illegal act. So they're trying to blame it on police training. The police department trained him wrong. Was that an issue at the trial? Or are they making that up now?
Can you say that again?
All right, so their argument that Chauvin acted in good faith, this was an error made in good faith reliance on his own experience as a police officer and the training he had received. Was that something they brought up in trial?
Oh, yeah.
Is the police department that made him do this because they trained him wrong?
Yes.
Oh, okay. Yes. Okay. So, yeah, that would be a factor for downward departure. Sure.
And here's some breaking news about the tax evasion. This was, they're saying September 9th. I didn't see this, but apparently he already made an appearance in court on these tax evasion charges. I had no idea that this happened. So he did. And what it is it's on both him and his wife are being charged with not filing their income taxes, and underreporting their income.
Not filing them when? 2020? Did anybody file taxes last year? Plus, wasn't he in prison? I mean, jail, rather?
Let me see.
Yeah, how many years are they saying?
They are accused of underreporting $464,433 in joint income from 2014 to 2019, while owing a total of $21,853 in taxes.
How? That's not a small amount. Well, I don't know. I guess we'll stay tuned.
Yeah, and I don't see any thing that, in fact, it even says that his defense attorney didn't talk about the tax evasion when asked, so don't know what's going on there. We'll find out.
All right. Yeah, let's stay tuned. So he was convicted April 20th. I don't see anything about a hearing. They're asking for a new trial and a 54-page memo. Oh, we don't have that. We said we were going to get they filed the memorandum. We said we were waiting for that. Apparently it has been filed. So we got to get that for next week.
All right.
But yeah, I don't see anything about an actual date. So as far as aggravating factors, the number and severity. Okay, here we go. All right, so this is what you were talking about, Tiger. The aggravating factors, why the prosecution wants to go above the sentencing guidelines, and they are these. 1, Chauvin abused a position of trust and authority. 2, Chauvin acted with particular cruelty. 3, Chauvin acted in concert with 3 other individuals who all actively participated in the crime. And 4, Chauvin committed the offenses in the presence of children. So, I acted with particular cruelty. Now, I guess I'm sure they're going to broadcast the sentencing hearing, right?
And they say that while at the same time saying that he was negligent and reckless, but he also acted with cruelty.
Yeah, and he killed Floyd both intentionally and unintentionally.
Yeah.
Hey, what a fraud. What an absolute fraud on the legal system. But, hey, there's a lot of that going around lately, isn't there? In every state. Every state that I know of, anyway. Independent of the long-term damage a prison sentence would inflict upon Mr. Chauvin's life prospects, given his age, convictions for officer-involved offenses significantly increase the likelihood of him becoming a target in prison. Such safety concerns are evident by his pre-sentence solitary confinement in a high-security prison, Nelson wrote. Well, if it makes him feel any better, they'll probably put him in maximum security isolation again when he gets to prison. That's something I hope all cops are thinking about right now. And all corrections officers. My son called me out, what was it, a month ago when we were talking about this case, and he's like, well, shouldn't we judge everything by its case? And aren't you really defending the Constitution? You're not defending a police officer. You're not defending the person. You're defending the law and all this. All the things I've brainwashed him into believing since he was born about the sanctity of the law and your duties as a lawyer. And yeah, that's true. But at the same time, I hope this is a wake-up call to cops. This is what you have been doing to people with total impunity for decades, putting people in isolation, starving people, prosecuting people on false charges, lying on the stand. Everything that cops have done to people in this country, it appears has happened to Derek Chauvin. Not that I want it to happen to Derek Chauvin. I don't know him. I don't have an axe to grind against him. But I hope all cops are understanding this is what you have been doing to all of us. For how long now? Anyway, what's the next case? Let's talk about a different story before I go standing on a soapbox again.
Sure. Want to hear about the latest with Dylan Roof?
Yes, you were telling me about that. All right, so I don't know anything about that case, clearly. So what happened? What's new?
So he is sitting on death row, awaiting execution, and as defense attorneys do, they're trying to block the execution. Well, capital defenders, they're trying to block the execution. And I did not know this because I was not following the trial at the time. But they are arguing that the court had Dylan Roof act as his own attorney during the hearing in spite of his clear mental incompetence. Hence, the execution decision should be overturned. So,
which hearing?
Sure I got
a sentencing hearing?
Yes, for the execution.
Wait a minute.
So,
what do you? The court made him be his own attorney? Did I hear that right? That can't be right.
Yeah.
They made him be his own attorney.
Yeah. I don't want to say anything wrong, so I'm just going to read from the article here.
Okay.
In a lengthy brief, Roof's attorneys argue that an appellate court should vacate Roof's convictions and death sentence or remand his case to court for a proper competency evaluation. The federal trial that resulted in his death sentence departed so far from the standard required when the government seeks the ultimate price that it cannot be affirmed, they wrote, arguing that their client's mental illness should have prevented him from serving as his own attorney during a portion of the trial and also being sent to federal death row. U.S. District Judge Richard Gergel held 2 competency hearings for Roof, one before the start of his trial and one before its sentencing phase, to determine if Roof could act as his own attorney for that portion of the trial. His appellate team wrote that the court errantly found Roof competent, despite the fact that every defense expert agreed Roof suffered a delusional belief he would be rescued by the victors of a race war, which prevented him from understanding the threat of execution was real. See, now that is delusional. There's no white nationalists are going to come and save you and break you out of prison at any time. So yes, that is crazy.
Didn't Weather Underground rescue Timothy Leary? Didn't they break him out of jail?
I have no idea. I haven't heard that, so I don't know. That would be amazing.
All right.
If that happened.
Well, this is why God invented the internet, is so we don't even have to worry or wonder about it. We can just look it up. Weather Underground, Timothy Leary, escape. Let's see if that brings anything up. So, what is this set for? Is this in the appellate court?
Yeah, this is in the appeals court, yes.
So, is there an oral argument set on this, or what's going on procedurally?
If there is any kind of date or anything procedural coming up after that, I don't know. But I would imagine, I mean, they're writing this, they're arguing it, there would have to be some kind of hearing about it. The court would have to respond. So, but as far as to what to look ahead to about it, it doesn't tell me.
All right, well, let's stay up to date on that. That's an interesting story.
Yeah, I find it interesting. So what it sounds like happened is that they found Dylan Roof mentally competent to represent himself for his sentencing phase. So, I mean, that sounds like he sat there in court without any attorneys helping him out, telling him how to argue against the death penalty or whatever they were throwing at him at the time. Like, he was essentially defenseless.
Yeah, well, I don't know. It appears that there was never any competency evaluation done. But, I mean,
they say there were 2 hearings concerning his competency in that his witnesses that they had during the trial said that he was crazy. So there was that much.
Okay. Well, yeah, that's something I'd like to look into some more. I was not aware this was even an issue till today.
And what it says here is that while he was representing himself for sentencing, Roof successfully prevented jurors from hearing mitigating evidence about his mental health under the delusion, his attorneys wrote, that he would be rescued from prison by white nationalists, but only bizarrely if he kept his mental impairments out of the public record. So what Roof was doing during this sentencing phase was he was saying, I'm not crazy, and that that by doing so, that would get him rescued by saying that he was not crazy. So yeah, it just sounds awful.
Yeah, but maybe he really wasn't. Think about the Unabomber case, for instance. Think about Dr. Kaczynski. I think I've told you about the miniseries. What was that called? Manhunt. Manhunt is called. So it's like an 8-part miniseries, and it shows pretty well how he was railroaded by his own attorneys. His own attorney, who's a famous attorney. She also represented the Boston bomber. She straight up conned him and went for a competency evaluation, tried to have him declared insane. And he was like, no, you can't do that. I'm going to fight this. And it came down to, well, you got to take a plea then. Either you take a plea and you go to prison, or we can have you drugged up, say you're crazy, discredit your writing, discredit everything you've ever done, everything you've ever believed. So maybe Roof wasn't crazy, and maybe his attorneys thought they knew better than Roof, and his attorneys said, no, we're going to do the insanity route, and Roof fought him tooth and nail on it. That very well could be. Now, whether it was delusional for him to think that there was going to be a race war and white nationalists were going to come save him out of prison, who knows? I would think it's safe to say Roof wouldn't be the only person with that opinion. I know that we don't judge delusion based on whether more than one person believes it. Sometimes one person believes something and it turns out to be true while the rest of the world is wrong. And sometimes, groups of people believe something and it turns out to be wrong. Who knows whether it's delusional or not?
Exactly.
But
I mean, that's just life. People, they believe what they believe, and it really doesn't have too much to say about their cognitive functions. Like, I'm just trying to think some of the out there New Age beliefs or historical beliefs and things, and that's just the information that they got, and they believe it to be true.
Oh,
it doesn't mean that they are functioning as a minor. Their brain is like a 9-year-old's or something. It's just
right, and it doesn't mean that they were incompetent at the time of the crime. It doesn't mean that insanity is a legal thing. Competency is a legal term, right? I don't know which side of it they're arguing. Are they trying to make an insanity defense, like he was crazy and should not have been found guilty at all because of insanity, or are they just saying he shouldn't have?
know at least for the sentencing phase here, they're saying that
just that he shouldn't have been allowed to argue it because he wasn't competent.
Yeah, and
that's
also
a different
that
story.
Him representing himself, it precluded the ability of the jury to hear about details from Roof's past that could have been used to mitigate the government's inflammatory case for death.
Yeah, but I don't know, man. I'm skeptical that means he's mentally ill or that he has any problems.
Yeah.
Some people would have told Hitler that he was crazy for representing himself. He was crazy for making a show of his trial, but turned out all right for him. And not everybody obviously can be Hitler, but it could very well be. I don't know Roof. I don't know. I've never talked to him about it. I've never looked into his case very much, but it could very well be. He thought, this is my time to put this message out. I don't want this to be about my mental health. I don't want to say I'm innocent. It could be he made a conscious, rational decision not to bring that in. So lawyers can be slimy. Everybody knows that. They could do things against their client's interest. They could do things that they think are going to win the case. They think their client is stupid for not putting these things forward. Well, obviously, this is the way we've got to go. This is going to save you from being executed. And the person says, it shows in that series Manhunt, not saying this is actually what happened, not an expert on it, but if Dr. Kaczynski said, no, I don't want to go that route, I am fine being executed, If they're going to martyr me, they're going to martyr me. Maybe that's what Roof did. A very rational, conscious decision. I don't want this having to do with that salacious nonsense about mental health. I'm perfectly sane, and I want the message out there. So, just from what little I know, that's the road I would be willing to believe.
Maybe. Like you, I didn't really follow the case, just saw the headlines when it happened. At the time, I just... Yeah.
Well, this might pick up your spirits, Tiger. In September of 1970, the Weather Underground, after being paid $20,000, broke Dr. Timothy Leary, out of prison. Leary was at the time an LSD advocate and counterculture hero who was being incarcerated for a 10-year sentence due to the possession of 2 marijuana joints. The Brotherhood of Eternal Love, a counterculture LSD advocacy group spearheaded by Leary himself, paid the Weather Underground $20,000. So that did happen. I was remembering correctly.
Yeah, that's amazing.
Yeah, so is it insane to believe that a race war is going to break out and that these people are going to go rescue you from prison? I don't think that's crazy at all.
I would just say relying on it is probably not a good idea.
Relying on it as a legal strategy, maybe not. But I'm just saying crazier things have happened, and I think Roof would have had some historical precedent to back up his belief. Unlike a lot of the crazy things people believe that have zero historical precedent, which we won't get into. What else we got going on? We had, what about the Tibbetts case? You wanted to talk about that.
Yes, Molly Tibbetts. So that fell out of the news cycle for, what's it been, a year or two since that happened? And at the time, it was extremely... it was just all over the news, and you had right and left shouting at each other about it. Well, the trial happened, and last week, the illegal immigrant that was on trial for her murder was found guilty and sentenced to life in prison.
Undocumented migrant.
Or as some of the news call him, farm laborer. Just a good old boy working on old McDonald's farm like any old American.
Makes me like him more already.
Yes. But I really only wanted to provide that as an update for people because I remember at the time there was some people saying like, oh, nothing will happen and all that. Well, he's been convicted. He's been found guilty, and it was not a very long jury deliberation either. It was the same day.
Same day? Oh.
Yeah. So 7 hours, here it is. Deliberated for 7 hours on Thursday and Friday. So maybe not necessarily the same day, but it was a pretty open shut case. During the trial, what they found was that according to the police, he admitted to killing her once they caught up with him. And he said that what happened was he saw her jogging, and he said, in his own words, I thought she was hot. And so he ran after her and essentially try and get her number or who knows what. And then she rejected his advances, and he stabbed her multiple times to death.
Well, that's not very nice for a farm laborer to do.
Yeah. So.
Well, what about, you had something about a Cash Gurnan that you were...
Yes.
I can't... quite frankly, I can't think about this case rationally. I have avoided this case on an emotional level. The boy looks just like my son. So why don't you take the lead on this one?
Yeah, I mean, honestly, I hear you on that because it freaked me out so much that when it happened, I even kept my own wife from the news. So,
Well,
um,
let's explain in an elementary fashion to everybody what this case is, because I think everybody knows about it, but they might not know the names. So, what is
yes.
the.
Okay.
All right, so what are the facts that everybody does know about the case?
All right. So, what most people know and see is that there was a black guy who abducted a 4-year-old boy out of his bed at night. And all over the news and memes and infographics, you see this footage from the baby monitor where they where the guy walks in there and grabs him and takes on. I never even watched that footage because, like you, that is almost traumatizing to me.
Yeah.
Just somebody walking in. I deliberately avoid watching that myself. But I did go ahead and get up to date on the background of the case. Um, Let me make sure I get the names right here, just because there's a lot of people that were actually involved with what happened here.
Okay.
So the abductor is Darren Brown. He was charged only with abduction, not murder. The boy was later found dead on the street somewhere. And the prosecutors, we don't have all the information yet, but what it looks like is they don't know yet who actually killed that kid. So we got in black and white him abducting the kid, but there's no causal chain yet to convict him for the actual murder. But there's more to this. So one is that the boys were not sleeping in their parents' house. That was not the parents' house. They were at the dad's ex-girlfriend's house. And at the time, nobody even knew where the dad was. He himself has an extensive criminal record, and at the time, he had a bench warrant out for his arrest. He was out in hiding.
Do we know for what?
I believe it was actually assault charges. Like, I know that was part of his criminal record, at least. Like, he actually has a violent criminal history. And the ex-girlfriend, she's also got mile-long criminal history. So the actual parents, the biological parents, they're separated and divorced. And the mother, the biological mother, she did not know where her children were either. So, I mean, to me, it's just like so many people made so many mistakes here. And what I'm seeing in social media is people acting like that this is some case where a black guy walked into some random house looking for some random white boy to get, when this is the other key detail. The ex-girlfriend knew Darren Brown. They knew each other, and there actually might have been a relationship between the two. The boys knew Darren Brown as well. And we know for a fact he's been in the house before.
How do we know that?
So,
And what's the extent of the relationship between the ex-girlfriend and Darren Brown?
those details we don't know for a fact.
But it
the
wasn't a random
commentators
crime.
And everything that I've been looking at, who's been going over this case, that's what they've been saying. They're like, okay, there's strong speculation, but they know from evidence or whatever they're getting that for a fact he was in the house before, and that would make sense too. Just criminals they're criminals of opportunity. Like there's very few truly random acts. Like, I'm just going to go out and hit this guy, kill this person, raid this place. Rather, instead, it's usually, oh, I've seen this person before. Oh, I know this door they keep unlocked and things like that. That's usually how they operate. This was not random. We do know that the boys knew the man, the woman knew the man, and so thereby there was some kind of relationship going on. The extent, I don't have that information. The people I was listening to about the case, they were also saying that they didn't quite have all the details, but they know that they all knew each other.
Interesting. Yeah, that's news to me.
Yeah, and the only other detail I want to add just for closure is that the surviving twin boy is now living with the mother. The father, he put out a YouTube video where he's just crying about everything that happened and stuff. But I like all the facts, all the information, because to me it looks like some people did a lot of stupid things here.
Well, so if the ex-girlfriend knew Darren Brown, is anyone alleging that the father knew Darren Brown?
No.
No?
Or maybe not.
Well, that's something seems important to know.
Yeah.
But I guess we'll see what happens with that. Man, that is what a terrible story.
Yeah, it is.
I can stomach any of the crime in the world. I've represented a lot of people, but that is just one thing that, I don't know, it's never
and
stomachable.
because too, like, the kids trusted the Darren Brown, like they were friends or something, and like I said, he isn't being charged with murder. Maybe they went out before and somebody else killed the kid. I don't know, but it's unlikely.
I mean, how are they saying that the boy died? Was it by, being hit by a car, suffocation?
Let me see if there is information on that, because that is good. If I heard it, I didn't leave notes on it.
Yeah, I figured that would go a long way. Maybe they're keeping quiet on that so that...
They could be.
Yeah, maybe it's a police decision so that when they do find who did this, they can confirm it because it hasn't been leaked to the press.
Yeah, and that's something important that I think people should know, is that oftentimes, whenever you're following true crime, you'll see a lot of missing facts because police and prosecutors and defense, all of them are hiding evidence from the news. They're not letting things leak out, and oftentimes it's just to so like in the Zhang Yingying case, there was a lot of information that the police were hiding because they didn't want their chief suspect to know that they were onto him, and better switch vehicles and things like that and go hide. So That's something to often keep in mind. Well,
let's switch to a much happier story. What about you've got a court TV thing here. Minnesota Attorney General's office to prosecute case in Wright's death. This is one I don't know anything about. Who Dante Wright? Oh, Kim Potter. I'm sorry, I do know this. Okay, so this is the one where we saw the video of the police officers pulling over a car, and then the woman cop apparently believes she's pulling out her taser, instead pulls out her firearm and shoots the kid to death. So, all right, so what did you want to talk about in that case? What's going on?
So, they are charging her. And
I should hope so.
Yes. But let me get the name right. Nakima Levy Armstrong, a civil rights attorney who was among those demonstrating outside Orpit's house, said she was glad to hear Allison's office was taking the case. So that's the same prosecutor in the Chauvin case. However, she said she would accept nothing less than murder charges. The case rises to the level of murder charges, she said. This is not the situation where an officer should receive a slap on the wrist. I don't know why anyone should accept a manslaughter charge. So she's being charged with manslaughter, but a lot of people, including the civil rights attorney, is saying it should be murder. intentional first-degree murder, whatever they call it in Minnesota.
Okay, well, I don't know. I saw the video, and it's pretty clear. Okay, well, with a strong name like Levi Armstrong, I suppose this person's entitled to his or her opinion. So, what's the status procedurally on this? Like, has she gone to arraignment? Does she have pretrial coming up? Anybody know?
Not me.
Yeah.
This is fairly new news, and it's just the last I've seen about it is that she was being charged.
Well,
I would
I'm sure
imagine,
that
'cause
BLM
this is
will
actually
let us all
about
know.
2 weeks old, so I don't know. I feel like something will have happened, but they haven't showed me. So
Yeah.
I don't know.
I'm sure the rioters will let us know when it's time for trial.
Yes.
Can't possibly miss it. Well,
I mean, it's right there in Minnesota. They probably got all their gear and demonstration stuff. They got it already from the Chauvin case. They're prepped.
right. Let's see. I've got 2 more articles. I'm going to send you this whole thing because tonight, because everybody's microphones are working, we've got to talk about trial by combat.
Yes.
So let's talk about these other 2 cases first. I'm going to send them to you. Of course, I closed out the one window I needed. And while you're looking to these, I'm going to go through the chat. We haven't addressed the chat the entire night.
No, I can actually see the chat now.
How about that?
Thanks to your little life pro tip you gave me.
Well, I'm here to help. What can I say? So, just sent you the articles. The bottom 2 are the ones that don't concern trial by combat, so we can talk about those. One is about COVID lawsuits in New York, and one is about, I don't remember, something else. I'm having problems with YouTube right now. What is the other one? Oh, the ABA Journal. So that's a fun article about diversity in the legal profession.
Oh, that's always good.
And professors aim to show value of diversity in new study. This is for all you legal nerds out there, everybody who's thinking about going to law school. Most people will probably think this is not interesting, but I think it's fascinating. Articles published by student-run law reviews were cited more often after they adopted diversity policies for selecting editors, according to a study that will be published in the Columbia Law Review. The study, which was released Saturday, examined nearly 13,000 articles published by the main law reviews of the 20 most prestigious law schools over a 60-year period. It found that law reviews with race-conscious policies, such as setting aside a number of spots for minority editors or requiring the minority composition of the law review to be proportional to the minority composition of the student body, saw the median citations to their volumes increase by about 23% in the 5 years after they adopted the policies. Let's translate that. A law review is where the creme de la creme go in law school. If you're the top of your class, top 10%, you join a law review. If you're not in the top 10%, you join some other law review. But it's everybody, you got to get on a law review if you're in law school. That's how you know you're good at the school, right? That's how you...
Oh, they rejected me. They didn't know what was good.
Yeah, well, legal writing ain't what it used to be. I've got a few stories about that, but point being, your aim as a law student is to get on the law review if you want to be known as the top of the top law students, right? So what they're saying is, as in all things in Western society these days, you have to have more minorities on the staff of the law reviews. So that top 10% of your class, whatever. Nobody cares about that anymore. We've got to get minorities on there. Your other qualifications, whatever. We've got to get more minorities on it. Just like anything else in America. Firefighters, waiters, CEOs, whatever field you're looking at, you've got to have more minorities. And they're saying that this has actually done statistical, measurable good for the law reviews that have adopted these policies. And how do they determine that? Because they looked at law reviews over a 60-year period. 13,000 articles they looked at from the 20 most prestigious law schools in America. After they adopted these diversity policies, those law reviews were cited 23% more than they were. There's an increase in 23% since adopting the race-conscious policies. What do you think, Tiger? Bunk science or fact?
I'm trying to think what happened here. So are they saying that these law schools are deliberately choosing more diverse students to be on law review?
That's right.
Okay. I'm just stuck at how they can do that, because so there's two ways again on law review. One is the write-on, which is the method that I tried and they rejected me, where you write a legal essay in a legal writing competition. And then the other way is when you're in, like you said, the top 10% of your class. But in law school, it's anonymous grading. The professors can't see your names, and some of them I knew some who took great pains to make sure they had no possible idea who was writing what. And so that's why I'm stuck at. I'm just stuck at how they can choose more people of color, minorities, and gays to go into law review if it's anonymous grading. I can't recall whether or not the write-ons are anonymous.
Well, I was rejected not because I knew who it was, but believe it or not, because of the content of the articles that I wrote. Believe it or not, I was no more popular for my opinions back in law school than I am today. The more things change, the more they stay the same, as they say.
I did a competition. It was on about the Supreme Court, how they should rule on some type of surveillance technology, and then I later found the court ruled the exact way that I wrote. I'm like, I'm vindicated. They should have chose me. I was right.
Clearly, the Supreme Court read your article, so
yes.
Yeah, jokes on your law school. Yeah. Thankfully, no one has taken mine up, because mine was promoting a eugenics program, and to this day, I get flack about that, because legally speaking, I'm right.
If you still got that, you gotta send it to me. I'd love to read that.
Sure, I'm sure some offended libertarian has it on the internet somewhere too, but I will send it over to you. Thank God, though. Thank God that nobody read that and decided to run with it, because it could very well be implemented had they followed my suggestions, which, again, thank God they didn't, because we would all be bred out.
So going back to the article, though, so what they're saying is that more people are citing these diversely written articles than the non-diverse ones. And it reminds me of, you'll often hear about how the Chinese often cite Chinese science journals and articles, and thereby they boost their peer review status or whatever. They're just all citing each other.
Right.
And
exactly.
Yeah.
That's exactly what is happening. That's just like the Nobel Prize or any other, the Pulitzer Prize, whatever prize you're getting, whatever citation. It's obviously a circle.
Yep.
What's a non-offensive term? It's a circle. It's a tight circle, right, of people who like each other. So, yeah, there's no mystery behind how you get a Nobel Prize. No mystery about how Obama gets a Peace Prize after bombing everybody. Like, come on, you know how the game works. So same thing with law reviews, and that's the point of bringing this article up. Well, as if by magic, these guys all sign on to these race-conscious programs, and abracadabra, they have a 23% increase in citations. Well, clearly it's because the race-conscious diversity programs mean that your law review... That's right. Your law review is now better than everybody else's. You've got better articles. What an amazing, magical utopia that law school has become. But no, obviously that's not what's happening. They're all citing to each other. You have to be retarded not to see what's going on here. But this article is from the American Bar Association Journal. So they are trying to pull the wool over some law students' eyes, or the entire legal profession, I don't know. Which, this commentary will probably get me blacklisted from the American Bar Association forever, but come on, man. We all know the game here. We all know how you get a 23% increase after adopting race-conscious policies. Come on.
And, too, for maybe some of your listeners don't know exactly what law review articles are and everything, you can think of them as the legal journal counterpart to, science journals. So it's usually academic legal professors that are writing these articles to keep their jobs, just to be busy. They got to write something, so they do their research and write. And then the student law review, they are editing these articles. And in all of these journals, there's always going to be one student written article. And so what it's describing here is that these people writing these articles are essentially citing each other, is what's going on here. In court, in practical law, we will occasionally read these legal articles to get background on caught up to speed to legal subjects. Occasionally, you can see them cited to in court decisions, or even if you're in trial, just to say, according to this legal research, such and such statistics or something. So that's what they're good for. That's what they're used for. But it's a circle.
A very tight circle with people who like each other. So I said I was going to go through the comments, and I never did. But they're saying they can hear you loud and clear this time. So,
that is awesome.
Yes, thank goodness for that. And we've got this freak guy saying, "Hey, Augustus, we appreciate these podcasts." Well, thank you. We appreciate you being here, Mr. Freak guy. So, I don't know why they are hiding El Dragon's comments, but here you go. We've just uncensored you, El Dragon. Devin Dunham was acquitted on murder charges for a 2017 incident in Hardyville, South Carolina, where he shot and killed Ernest Martin Stevens, a 77-year-old white man. That is unknown to me. I do not know anything about that case. But send us an article, El Dragon, and maybe we can read about it next week. Well, we've got someone who appears to be a lawyer in the comments saying, "I thought it was just that the journals that publish those pseudo-scholarship articles get cited more." Yeah, well, there you go. So he's on the same page as us. And other academics can write on public policy and get published in a student-edited law journal. Really? I didn't know that. Did you know that, Tiger? You could be a non-lawyer and publish in a law review?
I'm not saying he's wrong. He might be right. I know that law reviews that I read, the only time I see non-legal scholars and such is like if they're printing a speech of a politician or something.
And a law review article. Interesting.
Yeah.
Interesting. Beer Hall Pooch says, "Great to see Augustus back." Well, thank you. Great to be back. Back in the arena, as Nixon would say. So, Who wants to talk about trial by combat? For the love of God, I've been trying to talk about this for 2 weeks now.
Yes.
Forget about COVID. We're done with the vaccines nonsense. Let's talk about trial by combat. So my friend asked me last week. I put out the newsletter, and it had a quote of what's his name, Rudy Giuliani. It quoted Rudy Giuliani as saying, "Let's have trial by combat," and he's like, "Is that a real quote, or were you just playing around?" I'm like, no, that's 100% a real quote. It was all over the news. Huffington Post. Yes. Everybody was just furious that Giuliani would say, "Let's have trial by combat," and then the Capitol riots, the worst thing since 9/11 happened right after he said that. So obviously, he was promoting this violence. But yeah, real quote, phenomenal quote. So I quoted
he said
it.
Trial by combat, and so a whole bunch of people walked into the Capitol building, and that's trial by combat.
Yep, obviously that's what he meant. That makes sense, right? So I'm posting in the comment thread here. This is this week's newsletter. If you are listening to this and you do not get the newsletter, if you didn't get it today, it's because you're not signed up to get the newsletter. So please follow that link that I just posted and join up. He's Beerhole Pooch. Before we start this trial by combat stuff, he's asking, "Are you interested in speaking to Mark Collette?" Of course I am. Of course. Yeah, I haven't been in the loop for a long time, obviously, for obvious reasons. But yeah, sure. Why not, man? Set it up. I think my email address is in the description, so go ahead and have him email me or however you want to set it up. I'm pretty easy to get a hold of. So let's see. Trial by combat. So you got the link to the newsletter. Is trial by combat still a possible form of legal action? Tiger, you had notes drawn up for this, though. You want to go over those first before we go to the articles?
Sure.
All right.
So first, I want to get this out of the way. When I was doing some extra research on trial by combat, almost every single article that I saw talked about Game of Thrones.
That's right.
I have no idea anything about Game of Thrones. I don't know anything about it.
What's wrong with you? What are you talking about? Are you even American?
I couldn't tell you anything about that show.
So when you got today's newsletter, and the quote was not Rudy Giuliani, but it was Tyrion Lannister saying, "I demand trial by combat," you didn't even get that reference?
I thought you were quoting a historical person.
Yeah, historical Tyrion Lannister of House Lannister, Game of Thrones, man. This is why you have to watch Game of Thrones, so that you are culturally literate. And you get the pop culture references. Everybody knows Tyrion. He's everybody's favorite character.
So, I mean, I just knew about trial by combat because, I did a bunch of reading on dueling and things like that when I was young. So I knew it was a thing. So that's my first disclaimer. I'm not a Game of Thrones fanboy or something talking about trial by combat.
All right. Well, I am. So let's see. So
I think the first thing to say is exactly what it is, because I think it's very fascinating exactly what trial by combat is. And it's exactly what the name says. It's a trial where the plaintiff and defendant fight each other. And whoever wins, they win the trial. So it is also called a judicial duel. So back in the Middle Ages, Middle Ages, it's a couple centuries, a bunch of countries throughout Europe, so there's not always consistency, but as a rule, a judge will order a judicial duel when there's no evidence regarding what's going on. So if it's literally a he said, she said thing and they're going to trial about it, he's just like, fight it out. That's how you're going to decide it. The other instance is where the evidence is one-sided, but the other person is adamant of their innocence. So that's going to be where it looks like there's all the evidence in the world against this guy, but the guy is still saying, no, it's all lies, I'm innocent. He can request, they fight it out, they have a judicial duel, and the judge will order it. There's also, because back then, dueling was a thing, people would often duel. If people were otherwise supposed to duel by society or maybe government order or something, then that's another instance. A judge can come in and say, yeah, you're going to do this thing, get in there. So that's the other instance. Some of the countries, they would, or jurisdictions, they would have it where, again, no witnesses, no evidence to these particular crimes. So, and all of these are what we would understand as felony crimes: murder, treason, back then, heresy, rape, abduction, perjury, and fraud.
Wait, you cannot demand trial by combat under those?
You can. That's when that's when a judge would more likely find
abduction, fraud.
Yes.
What else? All right, I got to hear this list again.
Murder, treason, heresy, rape, abduction, perjury, and fraud.
Well, those make sense. Who would be on trial for murder and not demand trial by combat? Unless the evidence is just overwhelming that you're innocent. You've got them dead to rights, but if you're going to die anyway, why not demand trial by combat? So it seems to me that the main objection to trial by combat is that it's barbaric. It doesn't actually determine who's guilty and who's innocent. But that's just laughable, right? Because do you really think that the modern jury trial determines who is innocent and who is guilty? Laughable. Laughable that people are so naive to think that, let's just put it in the hands of a jury. They're always going to make a right decision. They're rational adults, right? They're definitely going to weigh the evidence without prejudice. They're definitely going to listen to all of the facts, and they're going to arrange those facts in a logical manner and come to the truth of the matter. Nonsense. I think there was one of these articles that we've got here. They pointed out that trial by combat was not the thing. You still had rules of evidence. You still had ways to prove your innocence through documentation, witnesses, oaths.
Back then, law schools were a thing in Europe.
Right. There were plenty of ways to prove your innocence. Trial by combat was just a way. It was a way of proof. And it goes back to the Germanic tribes, where you would take the oath. Somebody in the comments here, the lawyer, Matt, he's saying don't forget ordeals. Yeah, fire branding or dunking in water, testing witches and stuff, those kind of ordeals. Those are fun. Speak of the devil, and she shall appear. Agent 156 is joined. So there were ordeals for testing witches, but still you had witnesses, you had documentary evidence, you had all of these ways to prove your innocence or the guilt of a person.
And by the way, I can go off about those witch trials, by the way. There's a lot of disinformation about those trials.
No. Disinformation by interested parties? You don't say. Pull the other one, Tiger. So, really, this notion that trial by combat is barbaric, it's ridiculous. Because think of all the barbaric things that go on in the legal system right now, today. And how much more dignified is it to allow a man who is being condemned, or who is looking at being condemned, to allow him to say, I want to keep my dignity. I want to fight. I want God to prove who is telling the truth here. Because that's what it comes down to. The old Germanic tribes would say that you have taken an oath. God is going to judge who the victor is. Obviously, if you had a David versus Goliath situation, God proved, the worth of David and his power and all that. That's the point of that story. But in a real trial by combat, you're not going to have some 90-pound weakling going against a 300-pound bruiser. Like, that obviously wouldn't determine anything as far as justice is concerned. They have rules for that. That we
challengers.
So if you can have the UFC, right, or boxing competitions, and they can figure out, hey, we should probably have weight classes because the 265-pound bruiser is probably going to wipe the floor with that 130-pound kid every time. So if we can figure out that in a sporting competition you need weight classes, don't you think that the brightest legal minds in European history could have figured out maybe we should think of some ways to make trial by combat fair? So that
they did.
They did, exactly. So why can't we now? Why can't we now? We just leave men in there to rot. Even if they did commit the crime, we leave them in there to rot in these concrete rooms, just completely shut off.
And by
can't
the way,
see the sky.
They're for the state. So challengers for the state, in criminal trials, they were prisoners. Those were the ones who fought for the prosecution. They would go and get a prisoner, and the prisoners would be freed from prison if they won 4 duels for the state.
Really?
Yes.
Nice.
So how about solving the prison problem that way?
That's incredible. Yeah, we seriously need to bring that back. The system that we have is just absolutely untenable. It's disgusting, the way that we treat prisoners, the way that we treat people who are either rightfully or wrongfully convicted. Although if you look at things like the Innocent Project, there are so many cases where innocent people are sent to prison for decades. So many times. And we just continue to lie to ourselves and say, well, this jury trial, it works better than anything we've ever had before. No, it doesn't. Gladiator games work better than the modern jury trial. Duels work better than the modern jury trial.
Yeah. And imagine that, too. Like, if we had this system in modern-day America, I mean, maybe it's a bit of a myth, I don't know, but you often hear about people in prison, they just spend all their time working out and lifting weights and such. A lot of them would love to be challengers for the state. And with how many criminal prosecutions there are, and you can imagine a lot of people claiming their innocence and wanting to literally fight for their innocence. That would be such a great system to help free up prisoners one way or the other, that they might die or they win their freedom.
Well, and I think that's the concern of the state, right? Or should I say of the people who now control the state. The concern is that you would get all these adventurers who would just fight just to fight. Like, if you are a pirate and you're going to have to walk the plank or be hanged by the British, what are you going to do? Of course you're going to fight. Like, you might as well have a fighting chance, and that's, I think... Oh,
I'd fight every trial.
Exactly. That's what everybody's concerned about as well. If we give them this chance, who would ever go to trial again? Wouldn't everyone want trial by combat? Wouldn't all of these criminals either walk free or kill other criminals? Like, it would be madness. It would be chaos. But obviously it wouldn't be, because historically most people did not choose trial by combat. We have still had the jury system. We've still had rules of evidence. We've still had trial procedure. Not everybody elects trial by combat because they don't want to die. People choose trial by combat because they truly think that God is going to decide the victor. And the victor will be the righteous.
But like I was laying out at the start, is that there were rules for when a judicial duel could be ordered.
Right.
Like, it was typically when there was no evidence or overwhelming evidence. But if it's like, a fact-finding mission can go either way, a judge wouldn't order a judicial duel.
Right. Like, you couldn't be ticketed with jaywalking and say, I demand trial by combat. I demand a duel. But we have one of those in the article, right? From Newsweek, of all places. Of course it's Newsweek. They would want to delegitimize this. Man asks judge to approve trial by combat with his ex-wife. I imagine that is not something that would ever have been acceptable.
Well, when it did happen, when it was fights between spouses, they would have or really a man or a woman, they would have the man buried in a hole up to his waist, and that's how they would make it a fair fight. They would handicap him like that. So, again, some jurisdictions, but they would always find a way, or it would be challengers. Like the wife would go and hire a challenger to fight for her.
Well, that still happens today. It's just the wife will hire a lawyer, right? Or seduce a lawyer. It happens. The
Yes.
Des Moines Register reported that a Kansas man has requested an unusual method of mediation in a divorce dispute. He wants to be allowed to challenge his wife to trial by combat. David Ostrom claims that his ex-wife Paula Ostrom and her divorce attorney have destroyed him legally. As a result, he wishes to confront the duo, quote, on the field of battle, where he will rend their souls from their corporal bodies, end quote.
Yes.
What an epic court filing that must have been. And this is last January. It's not like this is some 1980s article after he saw Highlander. This is pretty recent. He does not necessarily wish to battle Paula directly, though. In his petition, he grants her the ability to choose attorney Matthew Hudson to fight in her stead. So this guy knows what's up. Ostrom does not actually own the weapons that he wishes to duel with, so he has requested the Iowa District Court in Shelby County to give him 12 weeks of lead time to find or forge the Japanese-style wakizashi or katana swords he and his wife or her attorney will be armed with. Amazing.
I would go with broadswords, but okay.
Well, if the female was going to fight, she would be distinctly disadvantaged with a broadsword. I think a katana...
Right, yeah.
Yeah, that actually makes more sense. Yeah, but... spoiler alert, they didn't go for it, unfortunately. But God bless him for trying. There are a couple...
And they could have. They could have.
Could have gone with it, you mean?
Yes.
Yeah, there are several articles we have that ask, is it still legal in America? Did you get the one from Business Insider?
Yes.
Okay, because you see that picture there? I'm going to post this for everybody to see. You see that picture there with that short guy, the midget? Is he a midget or is he a dwarf? Anyway, that's Tyrion Lannister. That's the one who demanded trial by combat. That's where the quote is from in this week's newsletter. Here's the Business Insider article, everybody. Yes, Mattoids, I am on Gab, and here is gab.com/Emperor Invictus. Here is my Gab tag. So let's read some Business Insider. Trial by combat may still be legal in America. I repeat, trial by combat may still be legal in America. Americans have probably only heard of trial by combat, if at all, from watching HBO's popular fantasy series Game of Thrones. Some have argued, however, that based on an obscure loophole, the U.S. might actually permit this archaic form of justice. The supposed right dates back... Supposed right. Oh.
You know, that goes back to natural law. You have a natural right to fight, to self-defense. It can be argued, and I would imagine it was back during the European Middle Ages when natural law was considered the law of the land, that it was a natural, God-given right.
That's right. So we should edit this to say not the supposed right, but the God-given right dates back to Middle Ages common law, which followed Germanic tradition in allowing two parties to settle a dispute through combat in cases lacking sufficient evidence for a conviction. Trial by combat was still part of the law in 1773, when British Parliament unsuccessfully tried to ban it in response to the Boston Tea Party. Isn't that amazing? The Boston Tea Party came. We were rebelling against the British. and the British Parliament tried to ban trial by combat in response to the Boston Tea Party. What an amazing development. And what's interesting, even more interesting, is that they were unsuccessful in doing so. So trial by combat was not outlawed in America in 1773, despite the best efforts of the British Parliament. Indeed, it was still allowed in a murder case in 1818, when a British court ruled a defendant could invoke his right to trial by battle, even though no one had used the practice for centuries. That man, Abraham Thornton, got off scot-free when his opponent never showed up for the fight. A year later, British Parliament finally pulled trial by combat from the books. What a dark page in history. So, since 1819, it has been illegal in Britain. British common law matters because the 13 original colonies inherited it, according to Lawrence Freedman's Comprehensive History of American Law. I think we've discussed common law on this program before.
In fact, my interjection is, it's not just according to this guy. Back then, right, the states literally adopted the common law as their statutes, as their code, and these were called retention statutes. And I mean, as I'm sure this article, I believe, says, some others we have mentioned, but the retention statutes, a lot of them have never been repealed. And in fact, how do I want to say this? I know a state Supreme Court judge who told me that my state, the retention statute is still in place. So where the state law and constitution are silent on a matter, British common law is the law.
Yeah, as it should be. I mean, you can't just despite what Americans want to believe, you can't just make up society out of thin air. You can't create laws in a vacuum. So if there is a history, 1,000-year history for the people who came over here, legally speaking, that 1,000-year legal history should probably have some kind of roots and maintain those roots. So somebody is, I see. They told me to check my my Instagram. I have just done so. So I will have to get back to you after the show. Although the U.S. that's what I was going to say. So you were saying not just according to this guy, because they're saying according to Lawrence Freedman's Comprehensive History of American Law, 13 colonies adopted British common law. Now, that's not according to his book. That's what happened. Like, we don't need to reference his book. The common law is the law in America. So here's the difference. Most places have civil law, and it comes from Rome. Rome had the 12 tablets. We have these laws that we promulgate. It becomes the law. It is written, right? We have a written code of law. That's civil law. We don't have that in America. Well, we do now. That's not how America was formulated. We based our legal system on the English form of law, which was the common law. The Nazis in Germany famously wanted a common law in Germany. They didn't want a Roman-style civil law code. They wanted to adopt a more English style of law, the common law. And what the common law means is this. When William the Conqueror went and invaded England and took it over, and the Normans became the new ruling caste, or class, I don't know which is more politically correct. When the Normans conquered England, let's say, they ran into a problem where there was already a system of law, and if they were going to impose their Norman laws on the local population, it was just going to cause unrest, possible rebellion. So why not just let these people continue in their lives? We'll just collect the taxes. We'll have our own courts, but they can continue on as they were before we came here. And that turned out to be a successful policy. So what they did was whatever customs and whatever laws you had in place locally we're not going to change those. The laws that we issue from the crown, now that we are the King of England, that will be one thing. But your local customs, your local rules, however much it cost when somebody stole a pig from you, however much it cost, or whatever the punishment was when someone, hit your wife or stole your horse or whatever it is, we're just going to keep those in place. There's no reason to do a top-down civil code where we're going to tell you everything and tell you what's what. And that has been the English law for 1,000 years. And it develops. We have what's called case law. So that the case before you, if it is relevant to your case and it follows the same facts, that's going to be the outcome for your case as well. Hopefully, in a perfect common law world. So we adopted that when we made America, right? So, although the U.S. Constitution, which took many cues from British common law, did not mention trial by combat, some scholars argue citizens should possess rights until the government specifically limits them. What a biased article. Some scholars argue that citizens should possess right until the government specifically limits them. That's actually the entire point of American law. All of American jurisprudence is based on the notion that unless the government limits your rights, you have those rights. Unless they are specifically banned, you're allowed to do it. Yes. That was the difference between the American system of law and the Soviet system.
That alone is why I would say trial by combat is legal in the United States. It's not illegal until either a statute says it is, which maybe in some state there is. Maybe there's some state that explicitly says, hey, we're no longer doing British common law. But that, or a judge comes down and says, oh, no, trial by combat, that's not unconstitutional. Until then, it's illegal.
That's right. That's right. And this person is clearly going to side with the naysayers, and that's why all this loaded language with the supposed right. Or some scholars argue that we should possess rights. Laughable. The Ninth Amendment says that the enumeration of certain rights in the Constitution does not mean that the people don't have other rights too. Adam Winkler, a specialist in American constitutional law, told Business Insider. Thus, a defendant in the U.S. could at least make an argument for trial by combat, but the burden of proof would be on the claimant. They'd have to prove that it was lawful in Britain when the founders created the Constitution and that they didn't intend to outlaw it, Winkler said. Well, I think that's pretty clear. It was legal in Britain until 1819, as we just saw. And obviously, the founders did not intend to outlaw it, or it would have been outlawed, which it wasn't. Indeed, trial by combat could be seen as violating other parts of the Constitution, such as due process and cruel and unusual punishment.
Well, that's for the judges to decide.
Yeah, but that's exactly backwards, isn't it? Because the state doesn't impose on you trial by combat. It's not like you're being condemned to go fight for your life. You have the right to go to trial. The defendant elects trial by combat. It's obviously not a due process violation to allow a man to say, I elect or I demand trial by combat. It would only be a due process violation if it was imposed upon you. And same with cruel and unusual punishment. They're not cruelly and unusually punishing you by allowing you to exercise your God-given right to trial by combat. It's not cruel and unusual punishment to say, you may elect to maintain your dignity and demand trial by combat, which is your natural right given you by God. Call that a violation of due process or cruel and unusual punishment is exactly the wrong way around. Trial by combat might fail to satisfy due process, says Winkler, because the outcome of the case would clearly be determined by force instead of careful weighing of the facts.
Oh, we can't have that.
Can't have that. You know what we should do? We should just give it to 12 random people who may or may not be educated, who are probably not rational, and let them just decide about it in secret after gossiping for a couple hours. That's definitely a better way to determine and weigh the facts. But then again, says Winkler, the framers did have duels. It's arguable that they intended trial by combat to be part of due process. Unfortunately for legal theory, no U.S. citizens have tried to sword fight for their freedom. Well, that can't be true. We know that's not true. Of course people have asked for trial by combat and fought for their freedom. Another British guy tried it in 2002, however, as Leon Humphreys, a 60-year-old unemployed mechanic, claimed he could answer to his $40 traffic ticket by fighting a clerk at the driver and vehicle license agency with samurai swords. In his mind, European human rights legislation would still allow it, but the British court obviously rejected his proposal. How would a U.S. court respond? I think it would be a very short case, Winkler said. No court is going to take that claim seriously. It's a completely inappropriate remedy for modern society. Lame.
Yeah.
Lame. I don't know who Winkler is, but I don't trust him as a lawyer. So, let's read an article that's not neutered. Or by a neutered guy. Is trial by combat still a possible form of legal action? This guy's name is Ian Pilarczyk. I don't know him, but he's a lot more based than that other person. Winkler. Imagine you've just gotten a ticket for... Okay. No, we're not going to start there. Because he just did the same thing the Business Insider article did. Well, let's say you got a traffic ticket and you wanted to fight your way out of it. Like, that's not what trial by combat means. That's ridiculous. Come on now. You are automatically delegitimizing it by making it absurd. It's an argument to the absurd. It's a logical fallacy. Well, if we allowed trial by combat, you couldn't give out traffic tickets anymore because they'd want a trial by combat. Like, that's not what it means. You just read it, Tiger. You just read all of the offenses for which you could demand trial by combat, and traffic offenses ain't on there. So let's just skip that. A bit of legal historical context. Trial by combat, also known variously as trial by battle, wager of battle, or judicial duel, was a medieval form of criminal procedure in which the disputants in a legal suit fought each other, with the winner also deemed to have won his or her case. Alongside ordeals, which is what Matt the lawyer mentioned in the comments there, alongside ordeals, trial by combat was a common form of adjudication of disputes. Originally Germanic in origin, the Normans brought it with them to England following the conquest. So what I was just talking about with William the Conqueror coming into England and establishing the common law, with the common law came trial by combat. In the UK, its high point of use, that is trial by combat's high point of use, was between the 11th and 15th centuries. Trial by combat was not available in certain cases, such as if there was very strong exculpatory evidence against the defendant, or if he or she was captured red-handed, or if he or she had attempted escape following capture. A party lost by dying, being rendered unable to fight any further, or by crying craven, a lovely old word meaning cowardly, but originally being Old French for broken, meaning in this context, I am vanquished. So, if you tried to escape after you were caught, if you cried out, I am vanquished, if you were disabled and unable to fight any farther, or if you died, you lost and you were guilty. A defendant who was killed lost the case. Not that it probably mattered much at that point, but if defeated and alive, could be executed or declared infamous, meaning he lost all legal protections, privileges, and status. A defendant...
Well, too, if the person survived the duel but lost it, he lost the case. He would also be punished as per statute or the judge ordered or whatever, as he otherwise would be in a trial by jury.
Right. Right. So a defendant who defeated the plaintiff or was able to defend himself successfully from sunrise to sunset was deemed exonerated. The stakes were high for the plaintiff as well. If killed, he lost the suit. If he survived and lost, he was likewise rendered infamous. Interestingly, before being allowed into the ring to begin their trial by battle, the combatants often had to swear an oath that they had not resorted to sorcery. One such surviving oath reads as follows: "Hear this, ye justices, that I have this day neither eat, drank, nor have upon me neither bone, stone, nor grass, nor any enchantment, sorcery, or witchcraft, whereby the law of God may be abased, or the law of the devil exalted. So help me God and his saints." This goes back to the entire point of trial by combat, which is what I was getting at earlier, that it is an ancient custom because people truly believe that in combat, God decides the victor, and God is going to give victory to the person who is righteous. That entire concept of justice has been thrown out the window in American law. Nobody, not a single lawyer could tell you genuinely that they believe that a jury trial determines who is right and who is not right, who is guilty and who is innocent by God, right? No one, not the most Christian person, not the least Christian person, not the most pagan or atheist or Jewish, no one is going to tell you that a jury trial is in God's hands, in that God decides jury trials according to who is righteous and who is non-righteous, who is righteous and who is wicked. No one believes that jury trials turn out according to God finding someone righteous or wicked. That is, however, the entire basis of our justice system in the old days. That is the entire purpose of trial by combat, because God determines who lives and who dies, and he makes that determination based on your righteousness or your wickedness. And our throwing that out the window, it shows you how hollow and empty this justice system is. It is an atheistic, pseudo-rationalistic method of determining an outcome that, at this point, hundreds of years later, everybody knows is false. And yet we keep up with that lie every day. So that is why they take this oath that they have not resorted to sorcery, because they are not trying to flout God's law, God's decision of who is righteous and who is wicked, who will win and who will die. So, continues the article, why am I asking whether trial by combat is still a possible form of legal action? Just that question came up a few years ago in the UK. And then we have the stupid traffic infraction thing again. I'm pretty sure this is the same exact case that Business Insider brought up.
It is.
Yeah. So they eventually decided that it was not. That is,
because it's in the UK.
Mm-hmm, right, where they have banned trial by combat. English common law was received into the U.S. before the American Revolution. Following American independence, the common law remained entrenched here, albeit supplanted, modified, and expanded upon at both the federal and state levels over the intervening 2 centuries. Clearly, UK decisions regarding English common law are not binding on US courts. That means, since the Revolution, UK decisions regarding English common law are not binding on US courts. Before the Revolution, those cases actually are precedent. We still would cite to Blackstone or Koch or
yes.
Anybody pre-revolution, the English jurists, we still cite to those. We still, to this day, learn in first year of law school cases from literally 1300, where a man took a hatchet and put it in somebody's door. Like, we still learn about those cases. We still learn about the assizes. So British law before the revolution very much does weigh on American law. So he means, since the revolution, UK decisions regarding English common law are not binding on US courts. And moreover, trial by combat survived in the UK until formally abolished by Parliament in 1819, as we saw in the other article, well after American independence. Since we inherited the common law, and since subsequent repeal by Parliament has no legal weight here in America, and as it appears no court in the US has ever grappled with the issue, that leaves open the question of whether theoretically trial by combat may have survived as a legacy of our common law system. This would, of course, bring a whole new meaning to fighting it out in court. This guy is way more based than Adam Winkler and that Business Insider cuck. We also have the current affairs article, but this is so long that I feel like we could take a whole episode just reading this. Trial by combat and the myths of our modern legal system. This is really the heart of the issue. This kind of argues my point that, is it really barbaric? Is it really that much different than leaving it in the hands of the jury when you're trying to actually determine the truth of the matter? You know what? I'm going to post this in the comments, because what if we don't get to read the whole thing? We can't possibly read the whole thing. We've only got like 10 minutes left.
Yes.
So I'm going to post this in the comments so that you enterprising folks out there can read up on it. Everett says he's all for trial by combat. Bring back the old ways. I'm surprised. Everett's usually so anti-Germanic. Just kidding, Everett. All right, so I posted this in the comment thread so that you can read this at your leisure, but I did want to read the beginning of this. In Burgundy, in the year 590, the royal chamberlain was accused of killing one of the king's prized buffalo, which, at the time, was a capital offense. What is a capital offense, you might ask? It means you can hang for it. Capital offense is one where you die if you're convicted, right? So we've talked about that before on this program, the difference between real felonies and what we call felonies these days, like something you would be hanged for, right? Something that invoked the death penalty. So a capital offense, killing one of the king's prized buffalo, you die for that. So this is the year 590. With his life on the line, the chamberlain opted for trial by battle, designated his nephew to fight for him. The counterparty, the royal forester, fought on his own behalf. Although the chamberlain's nephew managed to fatally wound the forester, the injured forester killed the nephew outright. By the rule of the day, therefore, the chamberlain was judged to have been guilty of killing the buffalo in the first place and was executed. This was one of the earliest recorded instances of trial by battle, a legal procedure for resolving disputes that persisted in Western Europe for nearly 1,000 years. Couldn't possibly work then, right? Only 1,000 years this worked? Only 1,000 years. That's
clearly the founders didn't want it.
Clearly. That's why they outlawed it in every statute book they wrote, right? And that's why it's written into the Constitution, thou shalt not have trial by battle. Thou shalt not execute thy God-given rights, like freedom of speech, the right to bear arms, the right to not have soldiers quartered in your homes, the right to right against warrantless searches and seizures. You know, it's a shame they didn't write as one, the 11th Amendment, the right to trial by combat, but it seems like one of those things that's so obvious. Why would you need to write it in there? Like, why would you have to write in there, you have the right to fresh air. You have the right to breathe. You have the right to work. You have the right to, move with your family to another state. Like, why would you have to write that in there? Trial by battle and related procedures, such as trial by ordeal, tend to be popularly characterized today as the depraved, superstitious, barbaric practices of simpletons in the distant past who just weren't rational enough to devise a legal system based on things like evidence and statutory interpretation. In 1454, also in Burgundy, a man named Plouvier accused a man named Coquel of murdering one of Plouvier's relatives. Coquel claimed self-defense. Plouvier had no way to prove his claim but wasn't willing to drop the matter, so he opted for combat, and the accused Coquel agreed. The battle ended with Plouvier, the larger man, kneeling on Coquel's chest and gouging out his eyes. Having been thus found guilty of unjustified murder, the eyeless Coquel was hanged. What sort of society, we might ask, would resolve disputes using such base, might-makes-right procedures? For trial by battle in particular, what sort of backward system would allow whichever party could hire the strongest champion to prevail in legal disputes? because that definitely doesn't happen here, right? How many lawyers did the state hire in Chauvin's case to prosecute the man? Yeah, hired 12 lawyers from out of state to come to hang this guy, right? How many lawyers did O.J. Simpson have? How many millions of dollars were spent on the O.J. Simpson case? Like, we don't have that same system where you pay the most people the most money and you win. It's the golden rule. But these disfavorable comparisons of trial by battle and trial by ordeal with our current legal practices miss the mark on 2 counts. First, the past was not as simple as we might imagine it. Battle and ordeal existed not as entire standalone systems, but largely as methods of proof within sophisticated legal systems.
Again, they had law schools back then. That's where we get our term the bar. I mean, they had law schools, they had courts, they had well, not adversarial system, but they had the 2 sides there are lawyers. I mean, it's just ridiculous to think otherwise.
That's the conceit of modernists, to think that everybody who came before is barbaric and stupid. Like, all of this legal stuff, all these laws we have, all these concepts of legality, we just made them up when we got to the Enlightenment phase. We got away from religion and all those stupid superstitious things and mumbo jumbo from priests and whatever. We got away from all that. We made like rational laws. Just came out of nowhere, when we got enlightened. It's ridiculous. Modernists, whatever field we're talking about, they think that they just came up with it. Oh, well, we're so smart. But yeah, they had, like you said, law schools. Not only law schools, but civilization. We owe civilization to our ancestors, to our barbaric, benighted ancestors who killed each other to prove that they were innocent. So maybe just put that in your pipe and smoke it tonight, ladies and gentlemen. One could still prove their case by sworn testimony. Oh, here's what I was saying earlier. One could still prove their case by sworn testimony, by documentary evidence, or by appeal to a jury. But in some cases, particularly where there was reason to doubt the reliability of those more familiar methods, battle and ordeal existed as alternatives. So, if you thought, I don't know, I don't think the jury is going to be impartial. I'm in Charlottesville, and my name is James Fields, and I know that they all want my head. I don't think I can get an impartial jury. I can't move the venue. I demand trial by combat, because then God will decide whether I am righteous or whether I am wicked, whether I've committed this crime or I have not. That is a method of proof. And it's obviously not cruel and unusual punishment. It is a man's election to maintain his dignity and to fight so that God will be his judge. That's not the article. That's me ranting again. Second, we are not nearly as advanced as we think we are. The power dynamics laid bare in battle and ordeal will be familiar to any American trial attorney today, or simply any American who has ever been caught up in our justice system. The practice of American civil litigation, i.e. a dispute between 2 parties, far from being a noble quest toward truth, is largely an exercise in misery imposition. Whichever party can use the procedural rules to cost the other side more than they can afford, in legal fees, time expense, and reputational harm, is normally the victor. In trial by battle, it was considered completely fair to hire an expensive champion. Likewise, in our current legal system, the wealthy can retain very expensive law firms with armies of investigators and specialized software capable of processing millions of pages of documents, and a less wealthy party will retain whatever schmuck with a law degree they can afford. In the end, might still makes right. Meanwhile, criminal defendants undergo their own torturous ordeal, in which they often face the choice between pleading guilty and taking their lumps, or undergoing grueling public trials during which an agent of the state will endeavor to vilify, humiliate, excoriate, and do everything within their power to ensure the maximum number of years are taken off the defendant's life. What an amazing summation of the American justice system. As with much of history, the wide gulf separating the brutality of the past from the Enlightenment today is, upon closer inspection, something more of a puddle. I love this article, which is why I put it in the comment thread for you. Tiger, we are out of time tonight. Thank you for joining me. You have any closing thoughts for the audience?
I do want to make one thing clear because I'm sure people are wondering about it. In a trial by combat, if there were instances where the court would assign challengers to fight for those who are unable to fight, that would be elderly or infants or people with physical disabilities. The court would literally give them a challenger, a champion, to fight for them.
Like a public defender.
Instances. Exactly.
Like a court-appointed lawyer.
Yes.
How barbaric. So, Thought Criminal says lifetime imprisonment is far crueler than trial by combat and execution. I 100% agree. Those are going to be my final words for the night. Thank you, Thought Criminal, for giving everyone their closing thought. Lifetime imprisonment is far crueler than trial by combat and execution. We will see y'all next week. So good night, everyone.